Y'all, and today our video is going to be Depp v. Heard and going over each of their assignments of error. I am the loud little ducky, and let's get into it.
In the Court of Appeals of Virginia, Amber Laura Heard, appellant v. John C. Depp II, appellee. Appellee John C. Depp II's additional assignments of error. Appellee John C. Depp II, Mr. Depp, or the plaintiff, by and through his undersigned counsel, while not appealing the verdict in his favor, hereby submit the following additional assignments of error in the nature of cross error in the event of a remand. Number 1. The trial court erred in denying Mr. Depp's motion to deny Ms. Heard's plea in bar with respect to the anti-SLAPP immunity, and in denying Mr. Depp's motion for summary judgment with respect to Ms. Heard's anti-SLAPP defense. Boy, that's a mouthful. Preserved plaintiff's memorandum in support of motion to deny the remainder of the defendant's plea in bar. The motion the parties argued on January 29, 2021, and the trial court denied on March 24, 2021. Plaintiff's memorandum. In support of motion for summary judgment as to defendant's anti-SLAPP immunity, which motion the parties argued and the trial court denied on March 24, 2022, as further reflected in the trial court's order. We will go over what each of these are after we go through these and explain what they're talking about so we can better understand it. But number 2 is the trial court erred by excluding the expert testimony of Dr. Kimberly Collins, a forensic pathologist retained and designated by Mr. Depp. Preserved, the parties argued about the admissibility of Dr. Collins' testimony, day 23. Trial day 23, which the trial court excluded. Mr. Depp also made a proffer before the court on this issue, trial day 24. So that is one of the proffers they made, which is the reason they make proffers is so that they can bring them up on appeal. It's the correct way of doing it so that it can be preserved. Even though Amber says she does not know what preserved means in her depositions. All right, number 3. The trial court erred in overruling Mr. Depp's objection to jury instruction C, which required a finding that the statement was false instead of adopting Mr. Depp's proposed edit, which required a finding that the defamatory implication of the statement was false, and B, denying Mr. Depp's request to conform the special verdict form to instruction C, which was given to the jury over Mr. Depp's objection. Preserved, the parties argued about jury instruction C on May 20th, 2022. Plaintiff's memorandum in support of and objection to improper argument and motion for a curative instruction and revised special verdict form, which the trial court denied on May 31st, 2022. And this was submitted October 21st, 2022, with Ben Chu, Andrew Crawford, and they're out of the Washington, D.C. office, Camille Vasquez and Samuel Moniz. They are out of the California office, and then Jessica Myers, who is out of the New York office. So let's go in and see what all they're talking about. These were not submitted with this. I just went and did the research to kind of give the example of what they are claiming. Okay, so up first we have the anti-SLAPP that they were talking about. And here we have One is supposed to regard matters of public concern, with emphasis added. The defamatory statements Ms. Heard made about Mr. Depp in the op-ed are decidedly not regarding matters of the public concern, as they pertain to what allegedly occurred in her private domestic relationship with Mr. Depp. They go on to say that Heard's counterclaim for defamation, see op at 9 through 10, this is because the court's January 4th, 2021 letter opinion directly applicable here leads to the very conclusion Ms. Heard seeks to avoid, i.e., statements concerning what went on in the personal domestic relationship of Ms. Heard and Mr. Depp are not matters of public concern entitled to immunity under Virginia's. And it's going to be Virginia's law, I'm pretty sure. All right, let's move on. Okay, it was not law. It is Virginia's anti-SLAPP statute. See Exhibit B, letter opinion of January 4th, 2021 at 10. Whether, as Ms. Heard falsely stated Mr. Depp abused Ms. Heard during their marriage, or whether Ms. Heard publicly lied when she claimed such abuse had occurred, may be of curious interest to the public, but they are not of matters of public concern affecting a broader community beyond Mr. Depp and Ms. Heard. Mind your business. This isn't between anybody else. This is between the two of them. And it should be a fight between the two of them. But that's not how the judge ruled, so here we all are. They go on to further say, as Ms. Heard concedes the issue of whether Ms. Heard's defamatory statements in the op-ed are a matter of public concern is a question of law. That can be resolved by this court without the need for a jury trial. So they are saying that we don't need a trial to say, or we don't need a jury to say, is this between, husband and wife under their roof? Or is it the public's right to know because they're a public figure? I think it happened behind closed doors, so therefore it should not be put out into the public. Keep it behind closed doors. But apparently the judge did not see it in the same way. See op at 6. If her defamatory statements are found not to be a matter of public concern, the court may thus deny Ms. Heard's plea and bar for an anti-SLAPP immunity as a matter of law. See ID Alexis 2020 WL 7090120 at 20 to 21. Because Ms. Heard's defamatory statements accusing Mr. Depp of domestic abuse are not matters of public concern, the court can and should deny Ms. Heard's plea and bar for an anti-SLAPP immunity as a matter of law. So they're saying they shouldn't be a public matter. This is a private matter, and the community has no rights to this information. So they should have denied this being a public concern because it wasn't. But they denied, and they thought that it did concern the public and that we needed to have this trial. So that is why we were there. And if they would have dismissed it based on the anti-SLAPP immunity for her, slapped her case because it was private, then they could continue on, but I don't think it would have been as publicized.
Here we have a video of them putting a proffer on the record.
Thank you, sir. All right. Yes, Ms. Myers. Thank you, Your Honor. On May 25th, 2022, plaintiff intended to call Dr. Kim Collins as an expert witness in forensics pathology. Defendants objected on the basis that Dr. Collins had not been designated as a defensive witness and was designated only to rebut Dr. Jordan, which was defendant's forensic pathologist who had not been put up at this trial. Dr. Collins intended to testify as to whether Ms. Heard's descriptions of violence and injuries allegedly sustained by Mr. Depp were consistent with the photographic evidence at issue in this trial. She also, for incidents where there was no photographic evidence, she would have testified as to what injury she would have expected to see based off of the violence that Ms. Heard testified to. And finally, she would have testified as to her opinion as to the cause, or as to Mr. Depp's finger injury and what she observed, consistent, which was similar to what Dr. Gilbert testified to today.
All right, thank you. Any other?
Okay, this is number 3 of his assignments of error, and it is the special verdict form that was given to the jury. Now, this is a copy of what it would look like for each of the statements that Amber stated about Johnny. And so it goes into this thing, and it says, as to the statement appearing in the online op-ed entitled Amber Heard, I spoke up against sexual violence and faced our culture's wrath. That has to change in the Washington Post online edition. And it's the quote out of that is the headline. And so it goes through and says, do you find that Mr. Depp has proven all the elements of defamation? Answer yes or no. If you answer question 1A no, please proceed to question 2. If you answered yes, please answer yes or no to the following questions. Has Mr. Depp proven by a greater weight of evidence that the statement was made or published by Ms. Heard? The statement was about Mr. Depp. Now here's where their change comes in. It says that, or the statement was false, question mark. And so they want to take that wording out and insert this wording down at the bottom that says the statement about Mr. Depp was false, question mark. So they just want to add his name in it, which, okay, it seems to have Depp or Heard's name in each of these. I don't really think that it's that big of a deal. Maybe I'm wrong, but I really think that this point is, it's a nothing burger. Maybe it is an important view. I mean, there are verdict forms on 6 statements in total, 3 for Johnny and 3 for Amber. And so maybe they just want to say, make sure they say the one about Mr. Depp, because on the other one, it's going to say, the statement about Ms. Heard or something like that. So that people don't just get confused by the forms or something. I don't know. Apparently they still got the result that they wanted. They understood that the statement was false. And so I don't think it really mattered that it was, that Mr. Depp's name was in there. But let me know what y'all think on any of the 3 of Johnny's assignments of error, and whether you think any of them have any merit. I don't think it's a big deal on the verdict form. The second one that talks about the expert witness, I know the least about that one. And then the anti-slap that we went over, should the matter have stayed behind closed doors, or should it have been treated as a public matter for public concern because they're celebrities? So let me know on that. And then we are going to get into Amber's now. Okay. Amber's is appellant, designation of assignment of error. comes now appellant Amber Laura Heard by counsel and designates the following as her assignments of error pursuant to Rule 5A 25. Now, she has 16 assignments of error, so that is a lot. I guess they are throwing everything against the wall and seeing what sticks. But I think that's a lot, and I don't know if the appellate court is going to like that, because that just seems like you just want everything. We shall see what they have to say. But her first one is the trial court erred in declining to dismiss the action on the ground of forum non convenes. So let's look at what that even means. Okay, so forum non convenes is a discretionary power that allows courts to dismiss a case where another court or forum is much better suited to hear the case. This dismissal does not prevent a plaintiff from refiling his or her case in the more appropriate forum. So basically, they're saying that this trial should not have happened in Virginia. All right. But the Washington Post, who published this op-ed that Amber wrote, has a location in Fairfax, Virginia. So that is going to be tossed because there is a reason for it to be filed here. It doesn't have to be filed where parties necessarily live. This is a choice, and it was a good choice on Depp's team so that they could get around their case being dismissed due to anti-SLAPP laws, which is what would have happened in California. It wouldn't even made it past anti-SLAPP. So that one's a scratch. Scratch that one off. That's a nope. All right, number 2 and 3. I have these grouped together on purpose. And number 2 says, the trial court erred in denying the supplemental plea in bar and in ruling that the November 2nd, 2020 judgment of the United Kingdom High Court of Justice, Queen's Bench Division in Depp v. News Group Newspapers Limited, case number does not foreclose Mr. Depp's claims. Number 3, the trial court erred in denying the demurrer and plea in bar in the ruling as a matter of law that the 3 allegedly defamatory statements in the challenged op-ed are A, actionable as statements of fact rather than non-actionable expressions of opinion, and B, actionable as defamation by implication. Now, for points 2 and 3, I have done an in-depth video on Judge Ascarati's opinion letter on this supplemental plea in bar that was denied. And so if you want to watch that, I will have it linked in the eyelet. I will also have it in the description box so that you can go more into it and maybe understanding why this case needed to be brought. It didn't need to be dismissed, and all the little things that they were trying to play were not going to be a part of this. And so I highly recommend you go check that video out, and let's see what the next one is. Number 4, the trial court erred in excluding from evidence at trial the November 2nd, 2020 judgment of the United Kingdom High Court of Justice, Queen's Bench Division in Depp v. News Group Newspaper Limited, and it has the case number. And the reason that this is not going to be successful is because giving a judgment from a case between two separate parties, I mean, it's Depp and the News Group, not Depp and Amber. And the News Group isn't even a part of this case. The Washington Post is just the publication place. But there are no news groups or newspapers or publications that are being sued or a party in this Fairfax case. But also, it is going to be more prejudicial than probative. Judgments with another party in another case has no relevance to the party in current case. So it's not going to do any good for them to say, oh, well, Johnny sued another paper for defamation with something that the newspaper wrote about him in regards to his relationship with Miss Heard. And he lost to the newspaper. Yeah, that's going to be more prejudicial. And of course, Amber wants that prejudicial statement in there because she goes around thinking that she won and Depp lost. But she was not a party in the case. Number 5. The trial court erred in excluding from evidence at trial A. Medical records, including Miss Heard's contemporaneous communications with medical providers. Contemporaneous communications just means that what Amber was communicating to these medical providers, and they were taking notes at the same time as she was telling them what she's experienced. That is all it is. That is not about observations or anything like that, because no physical evidence from a medical provider, no one saw anything that they would tie to that. So, who are these medical providers? Well, we have Dr. Laurel Anderson. I believe she was one of the couples counselors, or Amber's psychologist, something. Dr. David Kipper, who was the primary doctor for Amber and Johnny. Miss Debbie Lloyd, who was Johnny's private nurse. Miss Erin Pilati, who was Amber's private nurse. Dr. Amy Banks, who I believe is another psychologist type person that Amber may have seen, or Amber and Johnny may have seen. Then we have Dr. Connell Cowan, which I know there's audio out there of Johnny talking about how he doesn't care for Connell Cowan because of him just always putting him on medications. And it's just one medication after another medication after another medication. And Johnny didn't like that. And I've heard there's a lot of statements saying that people think that this doctor is a quack, but we don't really have a lot of information on him. And then lastly, they said Dr. Bonnie Jacobs, who was the relationship one. So most of these people actually were in this trial. So there's that. But they go on to say, and B, Miss Heard's communications with several third parties, including Mr. Depp's employees and Miss Heard's employees, friends, and family about interactions with Mr. Depp, including the reports of drug use, aggressive and abusive conduct, physical abuse, and her fear for her safety. Notice they use communications. When you are communicating with somebody, you are telling them things. You're talking, just like I'm talking to y'all. This is communication. And if you were taking notes while I was talking, that would be contemporaneous communications based off of what I'm telling you. That's not evidence. And then reports. Yes, you report things to your doctors. You report things to your friends. And that is all by telling them. When somebody says go report to your supervisor, they mean go talk to your supervisor. Go check in with your supervisor. And here, reports means the same thing. She reported this. She told people this. Telling people something does not make it actually true. But let's go into why this evidence that they love to talk about, because, oh, it is mountains and mountains of evidence, why it is not admissible. And it was right in a judgment call that it should not have been, and it wasn't. But they were going to fight it because they think that these communications would have proved everything. But why it doesn't prove everything is because, number one, it's hearsay. And it's hearsay within hearsay, because it travels through multiple people. To Amber, to the doctor to the notes to the lawyers then ask things to the medical provider, and then the medical provider says this. That is a lot of people. And the fact is that through that many communications and the game of telephone, chances are what was first said by Heard is not going to be the last thing said by a witness that stated these things. Also, testimony and depositions played in court. Most of these people appeared or their deposition was played. If they weren't called and they didn't come in and testify, or they didn't come in and you didn't play their deposition, that is on them. Amber's team could have called the people that didn't testify. And the ones that did testify, or the ones that had their depositions played, they could have played information about things like that and just gotten them in, or a way to somewhat get them in, or a gist of it in, by merely asking them. That's it. But hearsay is not going to be allowed. And the appellate courts are not going to allow it either. They are going to say, yeah, no, that can't come in. Your mountains of evidence that you say you have is just hearsay. And you had your opportunity to call witnesses. Now, maybe they didn't call them because they were low on time. Whatever the reason was, it didn't happen. So therefore, we cannot appeal on something that did not happen in the trial. Number 6. The trial court erred in admitting evidence at trial related to Ms. Heard's pledge to donate money to charity and evidence related to Ms. Heard's alleged abuse of third parties. Well, pledge and donate are not synonymous, even though Amber thinks they are. And alleged abuse of third parties. I don't think anybody actually said that. But if you want to call it that, because you told somebody, you pledged to them that you were going to give them this money, $3.5 million each, to total up your $7 million total, and you did not follow through with that, I would say you abused these third parties. But why were they admitted? And I do not think that they were wrongfully admitted. They needed to come in, and here's why. Credibility and impeachment of previous testimony. Opening the door on evidence. Credibility. What is defamation about? It is about, who do we believe more? Who's telling the truth and who's not? Well, guess what? When you go and you say that you're going to do something, and then we find out you didn't do that thing, that is going to affect your credibility negatively. That is on you and nobody else. You didn't want your credibility messed with in that format. You should have donated the money. And in the impeachment part, when you got on that stand and you said, oh, I couldn't donate the money because I had to pay $6 million because Johnny was suing me, and then we find out that you had all $7 million of that money for 13 months prior to Johnny even suing you. You had every dime. And what did you do? You kept it. You didn't donate it to the Children's Hospital. You didn't donate it to the ACLU. Why the ACLU still has your back when you lied? You didn't even sign your pledge form. So you just went around saying you donated it, and then you want to say you pledged, but is it officially in a pledge because you didn't sign it? Doesn't look like you like to handle your business. You do not take care of your obligations. It is about yourself and yourself only. Don't worry about the six sick kids. Those kids don't matter. I need the money. They don't need anything. And then Johnny even tries to help fulfill your pledges. And he did so by sending the first payments to you to those charities. And you threw a big old fit because you say, oh, he's doing it for tax purposes. No, maybe he was actually doing it because he knew that you were not going to follow through. So he was going to save you the trouble by just going ahead and making those donations. But that didn't work with your plan. You can't pocket the money if it's going straight to the charities. So why did you do it? You don't like that your credibility was messed up? You don't like that you were called out for a lie? Your actions spoke louder than your words. And this is on you and nobody else. Maybe you shouldn't have lied. This would have never come out had you actually followed through with what you said you were going to do. Now deal with it. Number 7. The trial court erred in excluding evidence at trial of Mr. Depp's reputation as it existed prior to publication of the challenged op-ed and after the op-ed was published. I don't know about that. Because Rottenborn, at the end of his cross, the first time that Johnny was on the stand, read numerous headlines. Headline after headline after headline that talked about Depp and his reputation, or bad things that were said about Johnny. There was also testimony from people that want to talk about, oh, he was already losing contracts. Oh, he was always late. Oh, he was always high or drunk. He was a mess and everybody was getting tired of him. You had people come up on the stand and bash him. And then there were people that came in and said, no, that is not how we felt at the time. We felt like once these allegations, because they were more serious, came out, that we had to cut ties because we can't be in business with somebody who's alleged to actually be doing these things. Now, should they have stayed with him until he was proved? Or should they have actually talked to him? And he could have maybe showed them this is a lie? They didn't do that. But you had every chance to go over the fact that you think that Johnny's reputation was ruined before you even wrote the article. So how can you ruin somebody's career and defame them if their career's already ruined? That was argued already. There was articles that said things. You got to prove it that way. You had testimony. So the evidence that you're talking about aired, and they erred in letting it come in, is a lie. Once again, evidence was not excluded. And if some was, okay, but you still got in quite a bit. Enough to try to make your point. Just because you didn't win on it doesn't mean you didn't get the chance to. Number 8. You're halfway there. Number 8 says, the trial court erred in sustaining an objection during the cross-examination of Mr. Depp to a question about the truth of one of the allegedly defamatory statements on the ground that it called for a legal conclusion. So, I have a clip where there is an objection that is during the cross. I have it from his second time being on the stand, I believe. And it is legal conclusion. I went through the coverage of his first cross-examination, and I could not find an objection for legal conclusion that was sustained. So, this is the one I have. I don't know for certain that this one is the actual one that they're talking about. That will come to light when they actually file their appellate briefs in the next week or two. All right, so let's see this video here.
You testified, and I wrote it down before lunch. You said, when Ms. Myers asked you something about, how does it feel to make you, or how does it feel to be here? You said, I've been living with it for 6 years and waiting to be able to get the truth out. Remember saying that?
Yes.
You also said, I've spoken up for what I've been carrying on my back. Something to that effect. You remember saying that?
Yes.
And you've claimed several times in this proceeding, Mr. Depp, that this trial is your first chance to tell your story, haven't you?
Yes, sir.
But that's just not true, is it, Mr. Depp? That's not true.
No, for me it is true.
Okay, well, here's the thing. The fact is, Mr. Depp, when Dan Wooten wrote an article that was published in The Sun calling you a wife beater, you brought a lawsuit against The Sun in June of 2018, correct?
Yes, I put
And that was 6 months before Ms. Heard ever wrote her op-ed, correct?
I don't know.
And in the summer of 2020, there was a several-week trial in London against The Sun, correct?
Ms. Heard was not a party to that trial.
Not my question, Mr. Depp. In the article that The Sun wrote that you sued over, you sued for Mr. Wooten calling you a wife beater, correct?
Objection asked and answered.
Sustained. Next question.
And in the trial that you subsequently brought, you called a lot of witnesses, right?
I don't know what a lot is. I don't know.
Many people testified on both sides of the trial, correct?
Yes, many people.
And many exhibits were introduced, correct?
Like a trial, yes.
And you, just like in this trial, you were on the stand for several days in that trial, correct?
Yes, sir, I was.
And that trial involved the same factual issues that you are litigating here, which is whether you
Objection
committed
calls
domestic
for
abuse
illegal.
against Amber Heard.
Sustained objection. Next question.
You brought that case against The Sun because you were angry at The Sun for calling you a wife beater, correct?
Yeah, that's
And you
probably a
went-
pretty good reason.
And you went through that trial in London, correct?
I did indeed, yes.
Mr. Depp, you've already had a chance to tell your story, haven't you?
No,
Objection
there were
asked and
great
answered.
limitations in the UK trial.
No further questions.
All right. Redirect.
Number 9. The trial court erred in allowing Mr. Depp to argue or suggest at trial that the jury could award damages based on statements or conduct occurring prior to the publication of the challenged op-ed. Okay. I guess that you're not supposed to argue or suggest that the jury can award damages because of statements or conduct occurring prior. And so this is how it goes. The jury was specifically told that they couldn't award damages for things happening before the op-ed. So basically from the time that the UK judgment came down and before that, Depp could not be awarded damages for those acts prior to the 2021. It is only from the time that the article came out to present day. And I think that they did that. Yes, you have to go through the entire relationship to get through all the accusations and what she says she did and what she said that she didn't do this or he did this and he didn't do that. All of that. You have to go through the entire relationship. You can't just say, well, she wrote an op-ed, but, our marriage was before 2020, so we can't talk about things that were hurtful to my career prior to that. That's not exactly how that works. And I don't know that that's what they're trying to say, but they do not like the fact that he was awarded money. And they think that it should be reversed, basically. Number 10. The trial court erred in allowing Mr. Depp to argue or suggest at trial and the jury to consider whether the allegedly defamatory statements in the challenged op-ed were republications of statements Ms. Heard made in 2016 in connection with the domestic violence temporary restraining order she obtained against Mr. Depp. Why is this important? Because on the jury verdict form, it says, and it asks, is this statement made or published by Ms. Heard? So they have to decide if she made it or if she published it. And while the Washington Post published it, when she went and created a tweet and linked the article and said, I published this, then you are putting it to your followers. And Amber's followers and the Washington Post followers are different audiences. And so when she did that and put it up on her Twitter, she republished it so that all of her followers could see it, because maybe some of them are not followers of the Washington Post to even see it. So therefore, republication needs to be argued, and it is very relevant in this case. Number 11, the trial court, which rejected proposed jury instruction CC, improperly instructed the jury on actual malice. Well, let's see. Here is part of the jury instructions. This is AA, and it says, actual malice. Both parties have the burden of proving actual malice by clear and convincing evidence. To meet this burden, each party must prove by clear and convincing evidence that each statement was made or published. Number 1, with knowledge that the statement was false. Well, she would know if what she said is false or true, because she was there. She has firsthand knowledge. So if she says something that did not happen and she was there, she lied. It is a false statement. Or, number 2, so recklessly as to the amount to willful disregard for the truth. That is, with a high degree of awareness that the statement was probably false. She knew it was false. When she stated it, she knew what she was saying did not actually happen. And then it goes to say, actual malice is a subjective analysis that looks to the state of the mind of the person who made the statement. If the person who made the statement believed it was substantially accurate at the time of this publication, then it does not give rise to liability for defamation. Well, she would know if what she was saying was accurate, because again, she was there. Then they go to tell you what actual malice is not. In number BB of the jury instructions, actual malice is not ill will, hatred, or bias. The term actual malice should not be confused with the more common meaning of the word malice, such as ill will or hatred. Actual malice is not established merely because an author was motivated by ill will, prejudice, hostility, hatred, contempt, or even a desire to injure another. So they are saying this is not about feelings. This is about, was what you said false? And did you mean when you did these things that they were not true? If she said these lies, republished them, and did everything that she did, knowing that what she was doing was not true and it was a setup or a hoax, then actual malice is proven. I don't have instruction CC, but this is what was put out, and comparing it to other legal things in the Virginia laws, actual malice is stated correctly in these jury instructions. Number 12. The trial court erred in denying the motion to strike and to set aside the jury verdicts with regard to Mr. Depp's failure to prove publication by Ms. Heard of the statement, "I spoke up against sexual violence and faced our culture's wrath. That has to change." Well, let's see what happens with this. So, this is from a video that I did do. I will have that one linked in the description box if you want the full video on it. And I will put it up in the eyelet. But this explains how Depp proved that she published the statements. Here we have that December 19th, 2018, Amber Heard. And we don't see where it says retweeted. We don't have a box to where it was like she shared it and wrote this from the Washington Post. What we have is, today I published this op-ed in the Washington Post about the women who are channeling their rage about violence and inequality into political strength despite the price of coming forward. From college campuses to Congress, we're balancing the scales. And then she put the link in for her article that she wrote. And it says, opinion, Amber Heard, I spoke up against sexual violence and faced our culture's wrath, is what the rest of that title is. And it says, we have been opening now to bolster and build institutions protective of women. Let's not ignore it. And then it's got the Washington Post. So when you click on that link, it'll take you directly to her story. And that's where it talks about 2 years ago. I spoke up against domestic violence. And so now it's to her audience. She's linked it, even though she says she did not realize that the headline was there, or that's just, she couldn't change the headline. What she could have done is just not linked the headline. That's one thing she could have done.
I would have saved her some of this, because then it wouldn't have been republication. But then she also writes, today I published. So she is acknowledging that she is the writer of this. Whereas we also know in the post and in this article, it does say author of this opinion piece is Amber Heard. So it's got her name on it in 2 different spots.
Number 13. The trial court erred in denying the motion to set aside the jury's verdict with regard to Mr. Depp's failure to prove that the allegedly defamatory statements in the challenged op-ed each conveyed a defamatory meaning about him by implication, and that any such implication was both designed and intended by Miss Heard. Well, if she knew they were false, and she put those statements out there with her 2 years I spoke up against in 2018. 2 years was in 2016 when she filed a temporary restraining order on him. So that gives the connection. It shows you who she is implicating in this article, whether she says it by name. And so if she did this, it was designed and intended by Miss Heard. She meant to do this. If this was false and she went through with this, which it was shown it was, then she did design and intend this implication. She purposely did it. She even admitted on the stand that she did it. And here we've got the statement. Then 2 years ago, I became a public figure representing domestic abuse, and I felt the full force of our culture's wrath for women who speak out. That 2 years ago is the problem. That is where she messed up. Number 14. The trial court erred in denying the motion to strike and to set aside the verdict with regard to Mr. Depp's failure to prove actual malice by clear and convincing evidence. Yeah, I don't think that's how that goes. Defamation, here is the legal definition: the act of communicating false statements about a person that injured the reputation of a person, the act of defaming another. She knew it was a false statement when she communicated it. And she wrote it and put it in the Washington Post. She knew by saying these sexual allegations were going to mess with his reputation. So, through everything and proving the fact that it was a hoax and that what she said did not happen, her story and her evidence didn't match, that right there is the clear and convincing evidence. So I disagree with number 14. Number 15. The trial court erred in denying the motion to set aside the jury's verdict and in ruling that the jury's verdict in favor of Mr. Depp on his claims against Miss Heard and in favor of Miss Heard on her claims against Mr. Depp were not inherently and irreconcilably inconsistent. They can be, though. But here we say verdicts cannot have conflict in meaning in the factual findings and outcomes. And I don't believe that they did. Here is why. This is part of the jury form. This special verdict form includes each of the statements on which Amber Heard bases her claims for defamation against John C. Depp II. Answer the questions in accordance with the court's instructions. And it says that as to the statement appearing in the April 8th, 2020 online edition of the Daily Mail, Amber Heard and her friends in the media use fake sexual violence allegations as both a sword and a shield, depending on their needs. They have selected some of her sexual violence hoax, air quotes, facts, as the sword, inflicting them on the public and Mr. Depp. And so then it asks, do you find that Ms. Heard has proven all of elements of defamation? No. So they are saying that what Adam Waldman said was not true. It was not, there was no sexual violence, and it was all a hoax. They agree with this statement. They do not believe it's false. Then on her second one, as to the statement appearing in April 27th, 2020, online edition of the Daily Mail, quite simply, this was an ambush, a hoax. They set Mr. Depp up by calling the cops, but the first attempt didn't do the trick. The officers came to the penthouses, thoroughly searched and interviewed, and left after seeing no damage to the face or property. So Amber and her friends built a little wine and roughed the place up. Got their story straight under the direction of a lawyer and a publicist, which she admitted to calling her lawyer, and Jody Gottlieb, her publicist, and then placed a call to 911. Do you find that Ms. Heard has proven all the elements of defamation? Yes. So in this, if you just watch the trial and these specifics in this specific order in the trial was not proven, because when the officers came, there was no wine spilt on the body camera. So I don't know if he was speaking in facts or if he was speaking in the fact that this is what he thought. And just because it's what he thought does not mean that is what Mr. Depp thought. We still do not know if Depp told Adam Waldman to do this. It has been denied that he told no such thing, but there is other evidence that didn't come into the trial that maybe should have on this, because there was 2 911 calls. One from Raquel Pennington, one from Io. That was not put up. Then, number 3, according to the April 27, 2020 online edition of the Daily Mail, we have reached the beginning of the end of Ms. Heard's abuse hoax against Johnny Depp. Do you find that Ms. Heard has proven all the elements of defamation? No. So they are saying once again that this statement of it being a hoax is false. They believe she set the hoax up. So why is this important? Because, number 1, where it mentioned a hoax, they said, yep, it was a hoax. And that this is not defamation because it's telling the truth. And number 3, same thing. But number 2 is detailed. And if you go by the details, this can make sense. But nowhere in this one, number 2, say that they believed it wasn't a hoax. Because they may not be saying that quite simply this was an ambush, a hoax. They might not actually be disagreeing with that. But maybe they disagree with the wine being spilled and then a second set of officers coming out. So I think it is purely okay that this one This one wins. This does not prove that it wasn't a hoax because the other ones say it was. All right, so now let's go through Johnny's. As to the statement appearing in the op-ed online entitled, Amber Heard, I spoke up against sexual violence and faced our culture's wrath. That has to change, in the Washington Post online edition. And so they said, has Mr. Depp proven all the elements of defamation? Yes. So they agree and say that these are defamatory statements, that she lied about speaking up against sexual violence in regards to Mr. Depp, because she did not experience sexual violence from Johnny. The second one is, then 2 years ago, I became a public figure representing domestic abuse, and I felt the full force of our culture's wrath for women who speak out. She is saying she faced the culture's wrath 2 years ago when she put that TRO out. Well, she knew that that was a false statement because nothing 2 years ago actually happened and was true. And this one was in regards to the print edition, a transformation or transformative moment for women. That is what this print article was, because there was a print article on the Washington Post and then there was a online article. So they are saying this is defamatory. This is not true statement. Number 3, as to the statements appearing in the entitled A Transformative Moment for Women in the print edition of the Washington Post, I had the rare vantage point of seeing in real time how institutions protect men accused of abuse. Do you find that Mr. Depp has proven the elements of defamation? They said yes. So they agree that all 3 of these are defamatory. She did not see in real time how people protected Johnny. Because the thing is she was believed for 6 years. And then, after everybody found out she lied and saw everything at the trial, that's when she started seeing things. But it wasn't because he was protecting a man that was abusive, because he was not the abuser in this case. All right, last one of her points. Number 16. The court erred in denying the motion to set aside the jury's verdict and upholding the amount of the jury's damages award in the light of A, Mr. Depp's failure to prove pecuniary damages, and B, the excessiveness of compensatory and punitive damages awards. I don't necessarily agree that it was excessive, and I believe that he proved his damages by having people that stated that he did lose out jobs. The WB and Disney then let him go based on these sexual violence allegations. So they admitted to that. And they didn't think about doing it until this article mentioning sexual violence came out. So I think he proved that there. Pecuniary damages, all demonstrable economic injury, losses, and expenses, regardless of whether the economic injury, losses, and expenses have yet been incurred. So basically, it is talking about money that he would have gotten had these statements not come out. What would he have actually earned? Doesn't have to be paid to him yet. But what should he have earned, but couldn't because of these statements and these false allegations? So what are his losses? Did he lose anything? Yes, he did. Damages is the legal term for a sum of money awarded to an injured person to compensate for his or her injuries and other losses. So we're not talking about injuries here. But, I mean, he did lose a finger. But we are talking about the fact that she destroyed his career with these statements because of the sexual violence. Because that was never mentioned before this op-ed. Okay, so I decided to do the math for all of this. Let's see if it's excessive. So, Johnny sued Amber for $50 million, which is actually half of what Amber was suing him for, because she was like, oh, he wants 50? Well, let's double it, because I want 100. She is a greedy gold digger. Oh, it's not about the money. I wanted nothing. She wants it all. She wants him to have $0 in his bank account and live a broke and lonely life with no prospects of jobs or anything. She wants to destroy him. But back to our mathing. So, he wants $50 million. Well, the jury awarded him $10 million in compensatory damages. So, we need to subtract the $10 million from the 50. That leaves us at $40 million. But then also, we have to subtract the $350,000 that he got in compensatory damages. Now, he was awarded by the jury $5 million, but the Virginia statute says that the max somebody can receive in punitive damages is $350,000. So it was reduced from $5 million to $350,000. So out of what he was asking for, and we subtract what he was actually awarded, he actually missed out on $39,650,000. So I don't think he won with an excessive amount, because there is so much that he was not awarded. Even if you took another $5 million off, it would just make it $36,650. So it's still a lot of money still on the table that he was asking for in this lawsuit. And he was not given all of his money that he asked for. Now, if they would have awarded him $100 million, yeah, I could see that that might have been excessive, because that's over even the asking amount. But that's not what happened. Now, they mentioned, the payouts and the money that he lost out on and he could have made. So, looked, and it is stated that Depp's yearly average income is $100 million a year. That is what he averages. Maybe a little more, maybe a little less, but on an average, he at least makes $100 million a year. And then you subtract it from 2018, when she published this article, which was 4.5 years ago. Well, he would have made, in that 4.5 years, $450 million. But he didn't get to make that because of her statements. But still, average loss after the verdict even, the amount that he won compared to the amount that he would have actually made he still loses out with his winnings $439,650,000. So nothing is excessive. It does not make sense to me that they are saying that this is excessive. I think it is just a ridiculous ploy. But hey, throw it at the wall, see if it sticks. I don't think it's going to stick. So that is all the assignments of error from both Johnny Depp and Amber Heard. And remember, all the different videos mentioned in this will be down in the description box below, and you can go check those out. If you like this content, smash that like and subscribe and turn your notification bells on so that you can be alerted anytime a new video is uploaded. And I will see y'all guys in the next video. Bye.